Unlike in financial matters, the court operates something called the no-order principle when it comes to arrangements for children. This means that unless you have an issue that you need the court's assistance with, there's no need for the courts to become involved, and you don't need to file any documents. For many couples, they are able to reach agreement for arrangements for the children, and this is often informed by the practical day-to-day arrangements. For example, where people live, what people's work commitments are, and what the children do day to day. Whether you are married or unmarried, the rules are the same, as long as you both have parental responsibility. Parental responsibility is a legal term for the rights and responsibilities that parents have for their children, and the focus is very much on the latter. Parents are responsible for ensuring that their child's needs are met. This can include being involved in welfare decisions such as where the child goes to school and whether important medical treatment is required. All mothers have parental responsibility, and fathers have parental responsibility providing the child was born after the 1st of December 2003 and they are named on the birth certificate. If you don't have parental responsibility for your child, the first step is to try and agree this with your former partner. If this is not possible, then you can apply to the court for a parental responsibility order. It's only in exceptional circumstances that parental responsibility will be removed, so even parents who may not have seen their child for some time will still have parental responsibility. This means that they are still responsible for the welfare of that child, and this may include being required to pay child maintenance. Family law is much more focused on the rights of the child above those of the parents. However, one of the child's most important rights is that they are able to have a relationship with both parents, providing it is safe for them to do so. If both parents have parental responsibility, then they have equal rights and responsibilities in relation to their child. In practical terms, the parent in whose care the child is in is going to make day-to-day decisions, and it's reasonable for them to do so. However, when there are major life decisions, both parents do need to be involved. For example, where a child lives with one parent during the week, that parent may elect to keep the child home from school if they're unwell and doesn't need the approval of the other parent to do so. But if that child subsequently needed serious medical treatment, then both parents would need to be involved in that decision. Agreeing arrangements for children could be one of the most difficult aspects of separation, and for some couples it's not possible to find a way forward. There are various different procedures that can be used to help you to find a solution, including therapy, mediation, arbitration, or court. Separation is a difficult time, and for some parents it can be a struggle to focus on the arrangements for children while they're also processing their own emotional reaction to the breakdown of their relationship. Counsellors, family therapists and bespoke parenting workshops can offer support and help parents to rebuild their communication and work together for the benefit of their children. Where children are experiencing difficulties, specialist therapists can work with the whole family to find solutions to the issues that have arisen and to find a better way forward. Mediation involves parents meeting with an independent mediator whose job it is to provide a forum to discuss the issues that may be preventing parties reaching agreement. Mediation offers an excellent opportunity to agree flexible and versatile arrangements that work for you and your family, and which might not be achieved if you used another process such as going to court. Mediation also allows parties to feel a sense of control over the arrangements, which is a real benefit for you and your family. Mediation involves you and your former partner attending sessions with an independent mediator to discuss the issues that have arisen between you. Where you are struggling to reach agreement, the mediator will work with you to identify the problems and try and find solutions. When matters are agreed, the mediator will then draw up a memorandum of understanding, setting out what has been agreed, so that you and your partner have clarity going forward. Arbitration is a form of alternative dispute resolution that results in a binding outcome. This means that if you and your former partner agree to attend arbitration, then you agree that you will follow the decision made by the arbitrator. Arbitration is therefore useful where it's not been possible to reach agreement through mediation or negotiation, and where you don't want to go to court. Some of the benefits of arbitration include the fact that you're able to select your arbitrator, which means you can ensure that the person making decisions in your case is someone who has specialist knowledge of the issues involved. By selecting your arbitrator, you can ensure that you have continuity, so you'll have the same person dealing with your case throughout. You also have a greater deal of flexibility, so that the arbitrator can look at all of the issues relating to children, or can deal with more discrete matters such as holiday arrangements or which school your child goes to. Arbitration is usually a much faster process than going to court, but it can go at the pace that works for you and your family because you have that sense of control that you do not have when you go to court. Where parties can't reach agreement, one party may elect to make an application to the court for assistance. This is usually done by way of an application for a child arrangements order, which enables the court to look at where a child lives, who they live with, how they spend their time, and other issues relating to the child's day-to-day life. Applications can be made in relation to any child under 16 who lives in the jurisdiction of England and Wales, and the matter will then be allocated to the court local to where the child is based. However, in cases where there are welfare concerns or where views are entrenched, it may be necessary to get the court's assistance. Welfare concerns could include not only physical harm or neglect, but also emotional harm or the deprivation of a relationship with one parent. When the court determines the welfare of a child, the paramount consideration is the child's welfare and ensuring that that child's needs are met. The court is required to look at the checklist at Section 1 of the Children Act 1989, which is known as the Welfare Checklist. The factors that the court needs to consider are the ascertainable wishes and feelings of the child, the physical, emotional and educational needs of the child, the likely effect on the child of any change to the existing arrangements, the age, sex and background of the child, whether the child has suffered any harm, and how capable each parent is of meeting the child's needs. The court must consider all of these factors before making any order in relation to a child. Consideration must also be given to what powers the court has and whether these need to be applied. The court must consider all of these factors when determining whether an order should be made in relation to a child. The court must also consider the no order principle, which sets out that an order should not be made unless there is a requirement to do so. If you have any questions about the issues mentioned, please don't hesitate to contact me and we can arrange an initial consultation.